Good afternoon, everyone. My name is Peter Alldridge. I'm the Draper's Professor of Law at Queen Mary, and I will be doing this taster class. I'm going to speak today about an issue that will be of concern for most of us. It's this: what do we do when a head of government is corrupt? I'm going to speak for about 30 minutes. If you want a question lined up, you can use the chat function, or you can use the raised hand function at the end. I have some technical support here, which will help me deal with those. This is an indication of the sort of subject matter to which you might be exposed in the LLM in criminal justice. In this case, in the course in Law of Economic Crime, corruption. So here's the issue. What should happen when there is a corrupt head of government? In the past, all over the world, there have not really been constitutionally or legally successful ways in which to deal with the corrupt head of government. The corrupt head of government will finish their term either by violent overthrow or by a democratic vote. And if the head of government does survive, then typically they will be left alone. And so practically, they have a certain amount of immunity. Or you can do other things. And I'll spend most of this talk talking about the other things, but just let's dwell for a moment on the bad things. People say, well, it's a matter for the political process leading to removal from office, and that can be done with full regalia in the open, as it was done, for example, at the trial of King Charles I before he was beheaded, or it can be done by taking somebody outside and shooting them, and that's the Ceausescu's going down in a hail of bullets. But much more commonly, actually, leaders who were deposed as a result of corruption ended up surviving and carrying on very nicely. Thank you, as, for example, in the case of corrupt prime ministers of England and Wales, who end up generally in the House of Lords, as was the case, for example, in David Lloyd George. So here are three, as it were, 21st century possibilities. The first is we just apply the normal procedures. We say, well, the president or the prime minister is not different from any other citizen. They should be subject to the same rules on investigation, prosecution, and so on, as would be any normal citizen. This is the case at least in theory, in the United Kingdom. We see it operating at the moment in Israel, where the Prime Minister Netanyahu is subject to criminal proceedings in court. There are some people who say, well, you shouldn't distract the head of government from the role that they need to discharge on everybody's behalf. And so they shouldn't have to be exposed to it, and they might be distracted. Well, I think the answer to that is it's true, but you might say the same when the head of government is ill, for example. Ultimately they can't be doing the job 24 hours a day, 7 days a week anyway, and they will be distracted, and a criminal trial is not that much more of a distraction than an illness or a love affair or whatever else heads of government get up to. The problems to be surmounted in the case where you just apply the normal procedures to the head of government are, well, who investigates and who prosecutes and who is accountable for the investigation and the prosecution. These are difficult questions. In Israel, the Attorney General, who was a member of Netanyahu's party, authorized the prosecution, and that is an impartial operation of the role of Attorney General, and he's much to be commended for it. Can we rely upon Attorneys General the world over to do that? I don't know. The second possibility is to say, well, the normal procedures apply, but they only apply after the head of government leaves office. The same kinds of questions will arise about who investigates and who prosecutes, because in the case where they've left office, there is always a danger that the prosecution will be an exercise in vengeance by people of an opposite party. Is the investigation subject to influence? Are they either friends or foes of the ex-head of government, and so on? It's a problem. Again, it can be surmounted, and it's recently been surmounted in the case of François Fillon, the former French Prime Minister. Remember, France has sort of two heads of government. The president is the more important, but they also have a prime minister. And he and his wife fixed up this arrangement for essentially a fake job for which she was paid a great deal of money. There have been investigations into previous French presidents, Chirac and Sarkozy. Chirac died. Nothing seems to have become of the Sarkozy investigation. There are also obvious difficulties actually in the conduct of a trial featuring a head of government. But they're not significantly different from any other high-profile figure, I would suggest. The third possible approach to the problem of the corrupt head of government is to have a separate sort of quasi-legal, quasi-political mechanism along the lines of the procedure for impeachment laid down in the US Constitution. Impeachment started life in England in the Middle Ages. It was a mechanism for bringing ministers to account. Famous episodes of impeachment include that of Francis Bacon, who was Lord Chancellor and was impeached in 1621 for taking bribes. He was sitting as a judge, and his defense, notably, was that he took bribes from both parties in the litigation before him, and so the bribes did not affect his decisions, and so there was no corruption. And he lost on that, but I do think it's a good argument. or perhaps more famously yet, the impeachment of Warren Hastings, of which this is a picture. Warren Hastings was a very significant and very corrupt governor of India, who was impeached between 1788 and 1795. Huge cause célèbre, everybody had a view on it, but it went on too long. Generally, it ended in, well, he wasn't really convicted. It was an unconvincing end either way. And impeachment in England and Wales was finally used in 1806 in the case of Dundas. The format of an impeachment trial is that it is an adversarial trial in which one house of a bicameral legislature, in the UK, the House of Commons, in the United States, the House of Representatives, acts as prosecutor, and the other acts as judge. This is the procedure for dealing in the United States with serious allegations against US presidents and other high officials, in particular federal judges, cabinet ministers, and so on. The House of Representatives impeaches, which is the equivalent of indicts, and the trial is before the Senate, and a 2/3 majority is required to convict and then again to remove from office. Now, no president has ever been removed from office by a conviction in a trial on impeachment. But in 1974, President Nixon resigned when it became clear that the Republican Party would not give enough support at his impeachment trial in the Senate to prevent his conviction and subsequent removal from office. Presidents Andrew Johnson and Bill Clinton were also impeached, but not convicted or removed from office. Now, the allegations of criminality against Donald Trump are legion and go back to the days before he took office as president. Some of them were performed while he was in office. And I've listed 11 or 12 here just to take you through them very briefly. There are allegations of money laundering. The connection between Trump hotels, and in particular the proposed Trump hotel in Moscow, Deutsche Bank, and the ruble. Excuse me. Then there are allegations that the Republican Party itself and the National Rifle Association were used as mechanisms by which money was moved from various overseas sources into the US. Third, there are sex trafficking allegations around Trump model management. I haven't seen any compelling evidence for those being correct. Fourth, there have always been claims about Trump's tax affairs, and those continue to this day. You will have noticed last week his tax returns were ordered to be made available to a grand jury investigating serious crimes in New York. And then there is the allegation of complicity in Russian interference in the 2016 US election, about which I'll say a bit more in a moment. But Trump is on the indictment of Paul Manafort individual one. The major deal which had been posited with Russia is something like this. And this deals with number one and number two. Russia specifically wants the Magnitsky Act sanctions, which are sanctions against significant, powerful, high up people in the Russian establishment, and the Magnitsky Act was first put in place in the United States, and similar pieces of legislation have been put in place across the world. There is one in the UK. Generally, Russia wanted influence over the UK. On the other hand, Trump wanted a hotel in Moscow, and that required funding, and it required consents, and it required money, in which Deutsche Bank were to be involved, and Putin was to get the sort of penthouse at the top of the hotel. Then to go on with the list of crimes alleged against Trump, it is unlawful for the president to profit from public office. Various presidents have in the past. It's contrary to what's called the Emoluments Clause in the United States Constitution. And the allegation is that by organizing things deliberately at Trump hotels or Trump golf courses, for which the state then pays, Trump is doing exactly that. He's profiting from the presidency. There are stories as yet unresolved about the finances of the inauguration. A great deal of money was raised to hold the inauguration. It wasn't spent in ways which have been accounted for, and so we don't know. The Trump Foundation is a charity. It has been conducted as a private slush fund, and Trump's children have now been disqualified from conducting any charity at all as a result of their misconduct. There are obvious allegations of nepotism, and quite seriously, because these are the sorts of things which in the past have generated successful actions against presidents, there are allegations of obstruction of justice. In particular, the allegation was that Trump fired a man called Comey as director of the FBI because he was concerned that Comey was investigating the links with Russia, and he wanted to stop those links being investigated. An investigation was set up by the Department of Justice into two things: allegations of Russian interference in the 2016 presidential election, and the allegation that by firing Comey, Trump obstructed justice. The investigation was probably not as incisive as it should have been, but it did bring many individual prosecutions against people around Trump, and it found on the principal issues which had been referred to it clear evidence of Russian interference in the 2016 US presidential election, and it found significant damning evidence of obstruction of justice. There was, however, no recommendation to indict the president because the person conducting the inquiry, a man called Mueller, regarded himself as bound by an existing but questionable Department of Justice policy that a sitting president cannot be indicted. So there's no recommendation to indict, to bring proceedings before a normal criminal trial. And also there was no recommendation to impeach. And that was because, or this was what Mueller said, and I believe him, he took the view that whether or not to impeach was a decision for the House of Representatives. And in that instance, the House Democrats decided not to impeach. And then in February 2020, there was a specific issue which did generate an impeachment, and that was Trump's phone call with Ukraine, in which he solicited action from the Ukrainian authorities against Joe Biden, who is his principal opponent in the forthcoming election, and Hunter Biden, who is Joe Biden's son. It goes without saying, you're not really allowed to do that. There are various things wrong with that. The Democrats were really pretty much forced to impeach under those circumstances, and they did. What Trump did was to make delivery of military aid to the Ukraine conditional upon their investigating Joe and Hunter Biden. And there were two articles of impeachment. The first alleging abuse of power, which isn't a crime, but which is a high crime and misdemeanor within the terms of the US Constitution. And the second alleging obstruction of Congress, which is a crime. Now, as I'm sure you all know, the result was that the Senate at the trial split. It split 52-48 on party lines, save for one Republican, Mitt Romney, who voted to convict. So they didn't get anywhere near to securing the 2/3 majority for a conviction, which would have been necessary. So you need 67 votes in the Senate to convict, and they only got 48. The president does have a pardon power, and we will hear more of that. It only applies to federal offenses. Equivalent powers in state law are held by the governors of the states. So he could still be prosecuted under state laws. Using the pardon power doesn't mean that person is altogether free, because once pardoned, somebody loses the right not to be compelled to incriminate themselves, and they may be subject to subpoena either by courts or by congressional committees. So these things might not go away, but here's what's really happened. That everything else is terrible, but this is the worst. This is the worst thing about the Trump presidency, to my mind. It is the betrayal of the rule of law and the example which it gives to the world in this regard, and in particular the behavior of the Attorney General, William Barr, since he took that post. Remember, we started off with the Attorney General of Israel deciding that the Prime Minister of Israel should be brought to trial. Barr has done everything to secure that Trump and his cronies are not brought to trial. The traditional constitutional position is that federal prosecutors are employees of the Department of Justice, and they make decisions independently of politics and political matters, and are not themselves political appointees. Barr's response to investigations and prosecutions and impeachment of Trump has been vigorously to attack the investigators, the prosecutors, and the people behind the impeachment. And he's done everything to reverse the outcomes which would normally be generated by the rule of law in many of the cases which were brought by Mueller. For example, he directed prosecutors in the Flynn case, which was one of the early Mueller prosecutions, not to accept Flynn's guilty plea and to try to generate a verdict of not guilty, and that is still before the courts. He has sacked the people in charge of the federal prosecuting offices in the three major jurisdictions dealing with political corruption. That's to say the Southern District of New York, District of Columbia, which is Washington, and the Eastern District of New York, and he has inserted his own placement, and he has taken direct control of prosecutions he wants to fail. In addition to which, sentences have been commuted, people have been released from prison who ought not to have been released, and so on. Which leaves some questions. What about the United States? Will we look back on the Trump era and say, well, the Constitution requires amendment? I think the answer to that is probably no. It's very difficult to imagine what the mechanism could have been that might have prevented the current dangerous state of affairs coming into being once you don't have the rule of law. And that's what Barr has secured for Trump. Then it doesn't really matter what the laws say. So you could fiddle about, for example, with the order of succession in the case of a stolen election. At the moment, as you probably know, it goes president, vice president, then the Speaker of the House of Representatives, and then there is an order of succession down. You might say, well, why would the vice president take over if Trump were removed from office? Because the vice president is complicit in many of the same crimes. It's really a sorry state of affairs. I don't think you can legislate to change it. I think, first of all, you have to restore the rule of law. As to the world, looking on and thinking about what kinds of mechanisms might do best to deal with the corrupt head of government, I think it's clear that the sort of quasi-political procedure, like impeachment, the mixture of the legal and the constitutional, only work if the decision-making body puts aside party loyalty. And whether it will, in any individual case, will vary from country to country. And so the value of this mechanism and other mechanisms varies from jurisdiction to jurisdiction. It might be that there are some in which it's good to treat the head of government like any other citizen. It might be good to have the sort of temporary immunity that operates in France in some jurisdictions. It might be good to have an impeachment type mechanism in some jurisdictions. But my point is, ultimately, unless you have the rule of law, it doesn't matter which of the mechanisms you adopt so as to try to go after the corrupt head of government. Okay, so that is everything I want to say, and I hope to see you in September at Queen Mary, either virtually or in the flesh, depending on the circumstances that obtain. In the meantime, please stay safe, and I hope that you and yours will remain well. Good afternoon.